How do you fight big tech censorship of free speech?
Argue that they're a state actor.
Viva Frei, Montreal litigator turned YouTuber, and this is Winnie the Westie getting ready for his afternoon nap. And for the last couple of years, we have been talking about Section 230 Communications Decency Act immunity. How do we fight big tech censorship of free speech? Well, Donald Trump has filed a lawsuit against Twitter, raising a relatively new argument, arguing that
Twitter has made itself a state actor.
And what would be the consequences of arguing that Twitter has made itself a state actor? Well, then it could no longer argue that it is a private company and therefore entitled to censor free speech. It would be something of a governmental entity and therefore would not be allowed to censor free speech. At the very least, constitutionally protected free speech. The lawsuit itself, I have my doubts that it's going to succeed. I actually think it's going to fail for a number of reasons, not the least of which is that Robert Kennedy Jr.'s lawsuit invoking the same argument recently just failed at the lower court level. But let's walk through this lawsuit so we can see what the allegations are. In the United States District Court for the Southern District of Florida, Miami Division, Donald J. Trump, the 45th President of the United States, Linda Quadros, and American Conservative Union, individually and on behalf of the class plaintiffs versus Twitter Inc. and Jack Dorsey, defendants. Class action complaint for First Amendment violation, jury trial requested. The first thing to look at is the choice of district, Florida, which means presumably that Donald Trump thinks this particular district is going to be more favorable to him than, say, the
District of Columbia.
Second thing to note are the defendants. It is not just Twitter, it is also Jack Dorsey personally, and we're going to get into this a little later on because of the allegations or absence of allegations that, in my humble opinion, could possibly justify holding Jack Dorsey personally responsible. Introduction. Plaintiff Donald J. Trump, the 45th President of the United States, individually and on behalf of those similarly situated putative class members, by and through the undersigned counsel, bring this action against Twitter Inc., Twitter, and its Chief Executive Officer, Jack Dorsey, individually. I'm operating on the basis that pretty much everyone out there already has a rough idea of the facts, even if they don't know that they already have a rough idea of the facts. But bottom line, Donald Trump's Twitter account was permanently suspended from Twitter following the events of January 6th on the basis that Twitter had to do it in order to prevent future violence. But Twitter's banning of the Twitter account of the sitting President of the United States of America was not the beginning of the censorship, it was the culmination of the censorship, hence the class action lawsuit for all of the people similarly situated who have had their accounts censored or suspended by Twitter. But the problem is that this type of censorship would otherwise be permissible because Twitter is a private company and they are not held to constitutional standards for respecting constitutionally protected speech. And so how do you get around that argument? You have to argue that Twitter has become a state actor. And how do you do that? Well, here is the argument in a nutshell. Twitter has increasingly engaged in impermissible censorship resulting from threatened legislative action, a misguided reliance upon Section 230 of the Communications Decency Act, 47 U.S.C. Section 230, and willful participation in joint activity with federal actors. Defendant Twitter's status thus rises beyond that of a private company to that of a state actor, and as such, defendant is constrained by the First Amendment right to free speech in the censorship decisions it makes. That is the argument, that Twitter is no longer a mere private company, that it is acting in tandem with or at the direction of the government such that it has become a state actor, such that it can no longer censor free speech because Congress shall enact no law that shall inhibit free speech. I think I may have misparaphrased the First Amendment, but you get the idea.
Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances.
So that is the argument. The only problem is that in law, all arguments need to be supported by the facts, and the question in this particular case is, do the facts justify this conclusion that is being sought? As a pure matter of fact, based on the allegations in this lawsuit, does this lawsuit allege enough to create a situation whereby Twitter has become a state actor? Let's go see, shall we? Democrat legislators in Congress feared plaintiffs' skilled use of social media as a threat to their own re-election efforts. These legislators exerted overt coercion using both words and actions to direct defendants to censor the views and content which Democrat members of Congress disagreed with of both plaintiff and putative class members. Not only did Democrat legislators openly voice their displeasure with defendants for providing a platform to plaintiff and putative class members, but they also spoke publicly of the steps they would take against defendants if defendants continued to provide a platform for the expression of views and content contrary to the legislators' own agendas. So the argument argument is that Democrat legislators were voicing their displeasure with Twitter continuing to allow Donald Trump and others espousing his political beliefs to have handles on Twitter to continue to use that platform to voice their political concerns, and they pressured Twitter into censoring Donald Trump such that they have now become a state actor. That is the argument based on those allegations. Now let's just go see the concrete examples alleged in this lawsuit. Below are just some examples of Democrat legislators threatening new regulations, antitrust breakup, and removal of Section 230 immunity for defendants and other social media platforms if Twitter did not censor views and content with which these members of Congress disagreed, including the views and content of plaintiff and the putative class members. Quote, let's be honest, @RealDonaldTrump's Trump's Twitter account should be suspended, end quote. Vice President of the United States, Kamala Harris, September 30, 2019. Quote, but I do think that for the privilege of 230, there has to be a bigger sense of responsibility on it. And it is not out of the question that that could be removed, end quote. Representative Nancy Pelosi, Speaker of the House, April 12, 2019. Quote, the idea that it's a tech company is that Section 230 should be revoked immediately, should be revoked, number one, for Dorsey and other platforms, end quote. Joe Biden, interview in December of 2019 and published January 2020. And the list goes on. I will freeze frame it so that you can read it yourself. The lawsuit then goes over the history of Section 230 of the Communications Decency Act. We have discussed it at length in previous vlogs, so I'll just read a couple of those allegations so that we can move to the other arguments in this lawsuit. Twitter is currently one of the largest of the social media platforms. Its growth and very existence have been directly authorized by congressional legislation. In 1996, Congress passed the Communications Decency Act of 1996, which amended the Telecommunications Act of 1934 with Section 230C, intending to promote the growth and development of social media platforms, as well as to protect against the transmission of obscene materials over the internet to children. Section 230C has accomplished and exceeded its original purpose in terms of promoting the growth and development of social media platforms. The lawsuit then alleges that Section 230 immunity has in fact allowed Twitter to become the social media behemoth it has in fact become. However, Twitter has utterly failed at actually removing the obscene content from the platform it was supposed to remove. Now, this argument may in fact be true, and I do think, as a matter of fact, it is true, but it might not be entirely relevant to this lawsuit because this lawsuit is predicated on the idea and the argument that Twitter has become a state actor and as such cannot censor in the same way the government cannot censor. So while I think Donald Trump is making a good point in this lawsuit and he is seizing on the lawsuit to make this point, I don't think this point is actually related to the essence of the lawsuit itself. But in furtherance of the argument that Twitter has become a state actor that is subject to constitutional restraints on limiting free speech, Trump argues that other federal actors have also benefited from Twitter's actions. Federal actors are also sharing the fruits of Twitter censorship of plaintiff and members of the class. These benefits include the Center for Disease Control, CDC, and the White House have used defendants to inexpensively and effectively promote their directives, messages, and policies concerning COVID-19 and to suppress contradictory medical views and content. Suppression of information suggesting or showing flaws in CDC and or other federal governmental policy, increasing the numbers of visitors to the CDC's website, and it goes on. It is going to be a pure question of law as to whether or not these allegations, even if they are assumed to be true, could justify or support the conclusion that Twitter has therefore become a state actor, and I am extremely skeptical that this lawsuit is going to succeed at that. Then, when it comes to the actual deplatforming of Trump, the allegations to hold Jack Dorsey personally responsible become even weaker, in my humble opinion. On January 8, 2021, Twitter issued a public statement from its @TwitterSafety account explaining the motive for removing @RealDonaldTrump. It states, after a close review of recent tweets from the @RealDonaldTrump account and the context around them, we have permanently suspended the account due to the risk of further incitement of violence. At the time defendant Dorsey was directing these decisions of constitutional import regarding plaintiff's free speech, defendant was in French Polynesia. Expressing his obvious discomfort with his decision in banning Trump from the Twitter platform, Jack Dorsey issued a public statement from his Twitter account on January 13, 2021. It states, I do not celebrate or feel pride in our having to ban @RealDonaldTrump from Twitter or how we got there. After a clear warning we'd take this action, we made a decision with the best information we had based on threats to physical safety both on and off Twitter. Was this correct? I don't see how these allegations could possibly be sufficient to hold Jack Dorsey personally responsible as a defendant, and the lawsuit really doesn't allege more to hold Jack Dorsey responsible personally, so I suspect this lawsuit at the very least will immediately be dismissed as relates to Jack Dorsey personally. Those are the allegations of fact in the lawsuit, and it's going to be a question of law as to whether or not those allegations, even if taken as true, could possibly justify the conclusions being sought in this lawsuit, and let's get to the counts of the lawsuit. Count 1, First Amendment violation. Defendants are vulnerable to and react to coercive pressure from the federal government to regulate specific speech. In censoring the specific speech at issue in this lawsuit and in deplatforming plaintiff, defendants were acting in concert with federal officials, including officials at the CDC and on the Biden transition team. As such, defendants' censorship activities amount to state action. I would love for this lawsuit to succeed, but based on the allegations in this lawsuit, I do not see how those allegations can justify this conclusion. I am thoroughly unconvinced that in law, being vulnerable to government pressure is sufficient to render that private actor a state actor. Count 2, declaratory judgment of unconstitutionality of Section 230 and the Communications Decency Act. Plaintiff restates the allegations set forth in 1 to 124. In censoring, flagging, shadow banning, etc., plaintiff and the class, defendants relied upon and acted pursuant to Section 230 of the Communications Decency Act. Defendants would not have deplatformed plaintiff or similarly situated putative class members but for the immunity purportedly offered by Section 230. Section 230C1 and 230C2 were deliberately enacted by Congress to induce, encourage, and promote social media companies to accomplish an objective: the censorship of supposedly, quote, objectionable, end quote, but constitutionally protected speech on the internet that Congress could not constitutionally accomplish itself. Section 230C2 on its face, as well as Section 230C1 when interpreted as described above, are also subject to heightened First Amendment scrutiny as content and viewpoint-based regulations authorizing and encouraging large social media companies to censor constitutionally protected speech on the basis of its supposedly objectionable content and viewpoint. Accordingly, plaintiff on behalf of himself and the class seeks a declaration that Section 230C1 and C2 are unconstitutional insofar as they purport to immunize from liability social media companies and other internet platforms for actions they take to censor constitutionally protected speech. The lawsuit then goes on to define the proposed class, because at the end of the day, this is a request for class action certification, and the proposed class is relatively simple: Americans who had a Twitter account as of 2018 who saw that Twitter account censored, curtailed, and suffered damages as a result. But the argument that Section 230 of the Communications Decency Act is unconstitutional because it immunizes private companies from censorship, I think that is a losing argument as well, because the private companies would have otherwise had the right to censor in any event. Even in the absence of Section 230 immunity, Twitter, if it is indeed deemed to be a private company, would have still been allowed to censor content on its platform, and this argument is diametrically opposed to the other argument Trump is raising, that Twitter has become a state actor. So unless I'm misunderstanding something, this lawsuit seems to be sort of sucking and blowing at the same time by arguing that Twitter has become a state actor and is therefore subject to constitutional requirements as relates to free speech, but the law itself is unconstitutional because it grants immunity to a private enterprise to censor. Anyhow, this will certainly start an interesting discussion, but the prospects of success of this particular lawsuit, especially given what just happened to Robert F. Kennedy Jr.'s lawsuit, I think this lawsuit is probably as close to dead in the water as it can get. And I say that despite wanting this lawsuit to succeed, I just do not think that this particular lawsuit is going to be the one that radically changes the landscape of social media censorship. And with that said, if you like my videos and you like my content, please be sure to like, share, subscribe, hit the notification bell, and drop a comment in the comment section below because it feeds the algorithm.
Tina, you fat lard, come get some dinner.
If you want to support the channel, all of the support links are in the pinned comment. Robert Barnes and I do weekly streams every Sunday. We do weekly streams with a guest every Wednesday called The Sidebar. We are also on Locals. If you want to find us and support us there, you can find us at
VivaBarnesLaw.locals.com.
All of my content is also on Rumble, so you can check me out there. But more important than any of that, take care of yourselves, check in on friends and family, make sure everyone around you is doing well, and now you know your vlog. Peace out. Booyah!